you know, I looked at it this way. You know, I said to myself, well, if I'm left out to dry, crash and burn, I'm not going down alone. So I just hit them with everything I could. Filed 21 motions. Every time I went into court, I attacked them.
Wait, I love this. You're a common man. 21 motions. Did you have a lawyer, a public defender?
No,
or
the way I go into court is I grab a standby attorney, okay? So I don't... you always should go into court in propria persona sui juris, which means pro se, which means yourself. You can't represent yourself as a pro se litigant because you are yourself. And when you say in propria persona, you're saying that in Latin that you are yourself and you can't represent yourself. So it's kind of a weird way of looking at it, but really important to the sense is that you're entitled to an attorney for any jail time. So they'll tell you, do you want an attorney to represent you? And you say, no, I'm representing myself in propria persona. And the fact is that then they give you an attorney. You say, well, I want counsel. You say, yes, I do want counsel, and I'm not waiving counsel. In fact, I have a counsel of my choice, and I'm going to have 5 more patriots as well as this licensed attorney. We're all going to sit down and counsel me while I do the whole trial.
Yep. I like that.
Right?
I like that.
You understand?
Yep.
That's perfectly legal. The counsel can't talk for you. However, a licensed attorney, if you instruct him, he can talk for you. Even though he doesn't file an appearance, we had a big fight over appearances, you see. Appearance means that you waive your right to speak, and the other guy, or the licensed attorney, represents you in whole and in part, and he's pretty much the boss at that point, okay?
Yes.
Because you looked at as an infant, a baby, a nobody, somebody who don't even can represent his own rights.
A case to get over before lunch. Yeah, I mean that's a case to get over before lunch.
Yeah,
it's no big deal. It's just another one. It's not. It's only criminal trespassing. It's not like you're going to jail over it. You know what I mean?
Oh, yes, yeah. You can do. Most people who get arrested for protesting for criminal trespass do 30 days.
Yeah.
Oh yeah, they all go to jail.
Yeah.
And every case that I've seen is everyone goes to jail.
Oh, I didn't know that. That's interesting. So you're up for jail time, and you represent yourself. What were the motions that you filed, and did you win on some of these motions? How did that work? The trial. What happened?
I was using a strategic plan. At first, I had gone in and I had filed motions. I did what they call a dilatory plea. Okay, and a dilatory plea, basically standing outside the court as a special appearance, special appearance meaning the fact that I'm there, okay, but I'm not joining the case. You see, to have a case, so both parties have to have a controversy, and the fact of the matter is I wouldn't join with them, because I was standing on the fact that the government should protect me, because my right to petition is protected under the Constitution. So it was kind of a oxymoron for them to be at the same time arresting me for trespassing for the very thing that they protect.
Exactly. You're right. I mean,
okay.
That's Supreme Court would say, I think you're right. I mean, how can
I know I'm right. But you see, the private property owner who's opened up his plaza, or the open common areas as they like to refer it to, when he opens this up, he has a right to time, place, and manner. And of course, my study showed me that the more you give them this rules and under time, place, and manner, the more they restrict them. For instance, Market Basket would restrict it to 1 day a week. Okay. Stop and Shop would restrict it now because they revised the agreement that I had formerly signed. They made a new one, and so they made it to 4 hours. And any complaints, they call the cops and basically oust you. And then there was one like Target was like 1 hour, 2 hours.
Mm-hmm. So they're restricting time. They're using this. All right. They know what they're doing. They're using this. Now, Now, how did you win this case? Was it a jury? Was it a judge?
No.
How did you win?
I was going to file. I have a case actually. Speaking of juries, all right. When you go to the next level of the court from the district court, they usually give you 6 jurors. Well, that's not what a jury is. A jury is 12. Okay, and you have to waive or agree to go that way. And of course, you have to actually, through U.S. versus Johnson, you have to be a belligerent and competent. And I say competent, not incompetent, but competent defendant. So you have to insist that you want 12. In the Constitution, insist that you have 12. So I was ready for that. I was going to file that. But what ended up happening to why I won the case, I think, is because, you see, I looked at a $100 fine and 30 days in jail. And I said, okay, let's see, that's what I divvied up, see what that cost them. And I said, okay, I'm entitled as indigent. See, I was indigent at the time. I says, I guess what I'm going to have to do is file for funds. So I filed for expertise, to look at the tape, and to see if it was defective after giving the court notice. Then not to ban the tape from evidence, I wanted to get photographs blown up, so I filed $500 for that, $600 for the prior, and then I filed $1,500 for a private investigator, which is all average fees that were essential to my defense.
Yeah.
So they had to pay those. So now they had to pay somewhat, $2,100 or something, or $2,600 or so to. And
what did that yield evidence? What did that bring about?
Well, no, when it came to when I went on the third, another thing that was on. See, I had tried to recuse a judge, all right, because of my discovery. All right, when I filed discovery, I did it under seal, and I did it ex parte, which means one-sided, so not to tell the prosecution what I was trying to look for, not to reveal it, okay? Because, that's evidential, all right, and factual. So I put it under seal and tried to deal with this judge, and this judge came, and his name was Zide, and he opened it up in open court and just started reading it, And I said, wait a minute here, I can't discuss it. The whole court's supposed to be empty, and it's just supposed to be you and I, and you're supposed to okay, subpoenas to get this stuff, and that way, after we get it, we decide if we're going to use it, then we give it to the attorney, a district attorney to look at too, and then he can decide whether he wants to continue the case or whatever. But the judge didn't do that. He opened it up and threw it all in the record and made a big trash bucket out of it, open to the public, and I objected. So the next time I went into court, I recused him. See, perjury, and what the officer did is he perjured himself because he used his skill of writing the complaints, okay, and he made up a complaint that was, how can I say, guided to the trespass notice. But if you time that with the tape, okay, and what he wrote down in the, which is what I was going to do at trial, if you time what is said in the complaint that he writes down that he does, comparative to what he is in action on the tape, there's only 30 seconds it takes for him to arrest me. And yet, if you start reading the 3 or 4 pages, there's a lot more there, and it takes a lot more time. And I was going to hit him right on the stand and catch him in perjury.